Yes. Uh-huh. Under the penalty of perjury, Bruce Hannafy? Yes. Uh-huh. Service of the temporary protection order entered into that cause number was never served upon Mr. Budnick? Yes. True and correct copies of the permanent order entered on July? Uh-huh. The traffic citation? Yeah. Just reading chapter 8, no contact protection order violation. Yes. That happened on uh, December 31st. Exactly what happened? Did anybody touch any member of my family, inclusive of the petitioner? Because was this what you used for a civil court um, violating of the restraint provisions of the protection order? Because knowingly violate a restraining or protection order granted? Yes. Restraining or protection order? Yes. Knowingly violating the restraint provisions of a protection order? Yes. Was there any actual domestic violence involved? Because as I remember it, I was arraigned, yes, in Clallam County, as if I had committed a criminal offense. You remember that, Officer Larson? Yes. Where you interviewed me and I asked for an attorney and then you didn't give me one? Yes. And then the state of Washington? Yes. Exactly how is the state of Washington involved in contempt of court hearings? I mean, well, we started with the state of Washington. Yes. Isn't that right, Mr. Calgill? Ooh, Mr. Nichols. Poo, poo. And I wasn't in Squim. I was on the bus that morning. I was in this library on New Year's Eve. Yes. And it says here on the 5th day of January 2016, I was arraigned. Yeah. It doesn't say anything about email to communicate, but that would actually be a violating of the restraint provisions, and that would be a contempt of court. Yes, it would. Yes, it would. It's a good thing you wrote that down, Judge. It's a good thing you wrote it down because it doesn't say anything in the traffic citation about emails. Yes. It says that in two different instances on December 31st of 2015, allegedly I was in Squim, Washington. Yes. Now, if it was an actual email that was sent twice, because I did accidentally send an email on December 31st. I said, give me every IP address in the world, which it was an accident. I know accidents are not allowed to happen when you issue protection orders. But if I had been actually arraigned as a contempt of court for violating the restraint provisions of sending an email to communicate with Heidi Budnick or other prohibited party, I think that would have been a contempt of court. What? You want to tell me what you did? Because I wasn't in Squim and I didn't email her on 7:47 in the morning. I know I wasn't in the library because the library doesn't open until 10 a.m. In fact, I wrote down every place I was that morning. I was at the Serenity House at 6 a.m. And I can get documentation to prove that. Then I was on bus 26, yes, and then I was on bus 20. Oh, and then I was at the YMCA, Papooch, and then I was at AA. Then I was on bus 22. Ooh, on bus 20. Yes. Then I was on bus 22 and I was at the Hagens, where the SARS is at. Yes. They probably had some video surveillance camera footage. So I couldn't have emailed Heidi until after 10 a.m. Yes. And I think the email was closer to 11:30 or something. I can get you a screen print of it. Ooh. Then I went to the Goodwill. It was closed until 6:30. Yes. Now this happened at 7:47, and I could have proven that I wasn't on the bus. Yes. On that morning to Squim or from Squim. Yes. And I can prove that I didn't actually email her during these times. Yes. So what really happened in Squim, Washington? Because I wasn't there. Well, you wrote down, do not use email to communicate. And I think that would fit the actual description of a contempt of court, unless, of course, it was inadvertent because somebody had intentionally obstructed thousands of emails that day. King County Administrator. Now, oh, Mr. Holders, former Attorney General of the United States. His law firm got an email. Now, you can appreciate the liability, yes, of having me arraigned for criminal charges, yes. When I wasn't in SQUIM, yes, the email would have been considered a violating of the restraint provisions, yes, that would have been a contempt of order. Now, you are absolutely sure that I had to have a mental health evaluation? Of all of those that have been found, well, as violating a court order, yes. Exactly how many restorations have been necessary when being found guilty of violating a court order where restoration treatment and psychotropic medication has been recommended? Now, here's another one, okay? Criminal complaint, right? Cyber stalking on June 16th of 2017. Is that is That's a violation of the restraint provisions of the court order? Yes. And then on or about June 16th, when knowledge had previously issued a restraining order, no contact order? Yes. Judge Landis has said, don't go to Brennan. Po. Now, I just want to know, did anybody actually touch any person? Was the petitioner touched? Because I wasn't in Brennan. Is there, are you absolutely fucking sure? Well, 1023, last known address, Kitchen Dick Road, Swim, Washington, 98382. Yes. You just can't remove the protection order. Pooch, you want to let me sue you? You're just going to keep yourselves out of prison by continuing to obstruct justice? You know, when I told the judge that I was not given any notice or opportunity to be heard, and he said, sure, you can speak at your own peril. Pooch, is there any possibility that the civil rights of myself, judge, I'm going to want you to remove your court orders because every time you arrested me, it was fraudulent. And for whatever happened in Squim, I wasn't there, right? But you put down, don't email. That